Good evening, ladies and gentlemen. My name is Kim Lee. I'm the Director of Partnership Development at the University of Law. We welcome you to this ULaw and IFA co-hosted event. Origins dating back to 1876 and a long history of evolution as early as 1962, previously known as the College of Law and incorporated by Royal Charter in 1975, the University of Law continues to provide specialist training and continual professional development around the world. The UK's largest law school, and with 19 campuses, including this one in Hong Kong, we are pleasured to tonight gather to provide you knowledge, education, and opportunities for professionals to excel in their careers. So, if you're considering opportunities, promotions, practical learning, and career excellence, my colleagues are available to provide insights to achieve this. They're seated at the back there. We offer a portfolio of postgraduate courses, as well as examination preparation courses aimed at law, non-law, and those in business, such as the SQE exams, the LLMs that are accredited leading towards becoming a ComSec or an INED. More importantly, upon completion of our courses, students are eligible to progress on to further studies to become lawyers in Hong Kong, England, and Wales, or to enhance their career in a variety of industries, not only in legal or in business. So without further ado, could I sincerely thank our panel speakers, Ms. Gwenda Ho from PwC, a partner there, for hosting this venue and becoming our speaker tonight. Mr. Rocky Mui, a partner from Clifford Chance, who you see behind me, and HKWJ Tax Law and Partners, and of course the Young IFA Network, Mr. Lucas Ting. Over to you, Lucas.
Okay, thank you, Kim. So good evening, ladies and gentlemen. My name is Lucas Ting, the Senior Tax Advisor at HKWJ Tax Law and Partners Limited. And I also happen to be the Chair of Young IFA Network. I'll be your MC and moderator tonight. Tonight's event will be roughly 1 hour, which at the end of the event, we invite you to a casual networking drinks at the Mo Bar. So again, my name's Lucas Ting. Besides blockchain and crypto, I have a passion with providing advice on Hong Kong, Australian and international tax and legal matters. So many of you may not be aware of what is Young IFA Network, or otherwise known as YIN. So it was established as part of the International Fiscal Associations, or IFA, with an aim to increase the participation of professionals in tax and law during the early stage of their career. The aim is to develop meaningful and long-lasting relationships between their peers from across the world. So IFA is an international non-governmental, non-sectoral and non-profit organisations dealing with fiscal and legislation matters. So we provide platforms where representatives from all industries, professions and government can meet to discuss fiscal, legal and tax issues at a macro level. So the sort of IFA members are lawyers, tax accountants, academia, tax administrators and judges. So if I may, I would like to take a quick survey. So how many of you are actually in fintech? Yeah. Oh, okay, there's one here. That's good. Then what about in legal or tax? Okay, so we've got a couple of guys in. Okay, that's good. So I guess regardless of which professions and industry you are in, we hope tonight's event will be informative and beneficial to you. So ever since blockchain technology following cryptocurrencies, then came the NFTs, and now the Metaverse and Web 3.0. So over the past few years, virtual assets and platforms have been widely adopted by investors as a new alternative investment. Values of these virtual assets have been very volatile. And with this, investors have also seen opportunities to make astronomical profits. So tonight we will be talking about cryptocurrencies, NFTs, and Metaverse from a legal, fiscal, and taxation perspective. So allow me now to formally introduce Mr. Rocky Mui and also Ms. Gwenda Ho as our panel speakers. So Rocky is a partner of Clifford Chance, Hong Kong. So he's in the fund and investment management team. He's also a senior member of Clifford Chance Global Tech and Strategy Committee, and he leads the fintech practice in Hong Kong. Rocky is a talent to keep an eye out for, and he's ranked as a rising star in the legal profession. Unfortunately, due to the 3-day quarantining, he cannot join us in person. Gwenda, she's a partner of PwC Hong Kong. She leads the corporate tax practice in the technology, media, and telecommunication sectors, as well as the national tax policy services. I'm extremely impressed with Gwenda's active involvement in a number of tax due diligence, corporate restructuring, cross-border tax advisory, tax investigation, IPO, and also blockchain and crypto-related projects. So over to you now, Gwenda. A few words for yourself, and if you can cover some of the challenges that are faced by you and also PwC.
Thank you, Lucas, and welcome everyone. This is one of the very first physical events that I've attended since COVID. So very pleased to meet everybody in person. In relation to your question, Lucas, the challenges faced by us in terms of virtual assets in general as tax practitioners, I think the major challenge is obviously the development in the space, which is moving at the speed of light. And when we started learning all this since 2017, it was when during the ICO boom. Basically, it was really steep learning curve for all of us. And after having understood how the industry worked, how the business models worked, we then had to apply the existing tax principles on these new concepts, these new models. And now in Hong Kong and many other jurisdictions, obviously the tax treatment is highly dependent upon the accounting treatment as well. And so we had to pull in our accounting experts to think about what was the proper accounting treatment for all these new concepts. But then there was also no specific guidance. And basically, they need to consider how to apply existing accounting standards to all these types of transactions. So basically, we had to develop from scratch a thought leadership on our own. And there was always an uncertainty because we had to assume that the tax authorities agreed with our view. So as you can imagine, tax authorities are always slower in picking up new things, new trends, new business concepts, because they are not as close as us to industries. So as practitioners, I think we not only have to advise clients without specific guidance, but we actually need to educate the tax authorities as well. And over the years, I think tax authorities are starting to pick up this trend, and tax authorities around the world gradually release guidance on the taxation of virtual assets, which is helpful to tax practitioners and taxpayers. But I think they still need to catch up. In Hong Kong in particular, the IRD included a section on digital assets in one of the departmental interpretation and practice notes. And actually, we had a chance to look at the draft and provide comments before they released the final one. So the guidance provided in the DIPN, what we call Departmental Interpretation and Practice Notes, is actually relatively general. And while it's helpful to see that the IRD's views are largely the same as ours, there are certain issues that have not been specifically covered. For example, how do you deal with unrealized gains or losses on crypto assets? How do you deal with crypto borrowing and lending? What's the treatment of staking, DeFi, etc.? All these have not been addressed. So until there's more updated guidance, I think we just have to make sure that we make our best efforts in considering these issues using basically existing principles.
Thank you, Gwenda. So I understand that you've been actually educating the IRD. So whilst you're educating them or lecturing them,
sharing,
okay. So what's your take with their kind of IRD's attitude? Are they positive with the whole virtual asset development and the way how they're going to tax these virtual assets, or they have a kind of negative attitude towards it?
I think they should be pretty neutral. Obviously, they want to learn. This is a new trend. So they basically, I think they need to learn from scratch, actually, because they haven't been as close, as I mentioned before, they haven't been as close to businesses as us. So basically, I think they really need to start from the elementary level to basically eventually catch up. Yeah.
Thank you. So now, Rocky, over to you. What about the, a brief introduction about yourself, and what about the challenges you and Clifford Chan face?
Yeah, thanks, Lucas. Good evening, everyone. Unfortunately, I can't join in person today, but hopefully I'll get the opportunity to meet every one of you in person again. Now, for a little bit myself, Lucas mentioned, I'm a partner of our Hong Kong Funds Investment Management team. So my team covers all the funds establishment work, whether it's private funds, retail funds, ETFs. We also cover the regulatory side of things, so anything around securities, banking, insurance, and the likes. And of course, fintech, that's one of my key areas of coverage. I lead a Hong Kong fintech practice and specialize in virtual asset and blockchain in particular. Now, I think it's in terms of challenges, I think it's quite interesting because how I see it as a legal practitioner, the challenges definitely are there, but it's part of the joy and fun to be advising on VA related activities, and it goes hand in hand. And as Gwenda mentioned, I mean, there's a lot of uncertainty, a lot of rapid development, a lot of learning process for everybody. But I think it's encouraging to see the whole ecosystem, and we have enough interested individuals, and of course institutions as well, really have the interest to develop this industry together. And it's amazing how kind of the government now is also on board, and of course with the latest policy statement they have, which is a really encouraging sign. So I think it's with the challenges, it comes with the opportunities and the fun and the joy. Yeah, I think just to share some in terms of on the legal side, one of the key challenges we see is you do need some technical understanding around virtual assets. Obviously, I'm not saying we need to be experts in terms of the actual technology. I don't represent myself as a tech expert, knowing how all the coding and everything works. But to advise on it, to advise our client, we do need a good understanding of what it is, the key features, and what it looks like. Because from a legal perspective, we do need to be quite careful about the actual legal parameters in order for us to do the categorization and analysis from a legal perspective. We then need a broad-based legal coverage, now, whether as an individual or as a firm. Now, it's in the context of VA, it's quite interesting. It comes in different shapes and forms, and it can basically be anything, depending on what you put on it. And from a regulatory perspective, we then need to think about, okay, we do need to categorize it. The legal thinking, we need to categorize it. Okay, what is it from a legal perspective? Securities, money, banking, and then we need to think about the services. Is it money remittance? Is it money lending? The list goes on, and there are other AML, whatever related legal issues involved. So with the different legal areas involved as well, so you add on the complexity. Okay, so what is it? What are the services? Then the legal areas. Okay, is it M&A related? Is it capital markets transaction related, or is it operation related exchanges, brokerage, market making, lending, and the list goes on. And even better, for virtual asset, most of the case you operate on a cross jurisdiction perspective. And in terms of operations, it will involve multiple jurisdictions and also your clientele as well. So you then multiply it to the number of jurisdictions involved. So it could get quite complicated. But as I mentioned, that's part of the joy of doing it. Obviously, for the individual from the business side, it's definitely not. But obviously, on the legal side, it's something that it's the process that we need to get through. But as I mentioned, we do need the broad-based practice. But fortunately, I have the luxury of having my team and also my firm's global reach in terms of covering different assets as well, which is a luxury to have. But it's definitely interesting to see kind of the challenges we face and how the ecosystem have been developing in tackling those challenges as well.
Thank you, Rocky. And as we can hear from Rocky, there's actually quite a lot of development and challenges faced by the legal practitioners. So obviously there are a lot of challenges facing by the tax and legal practitioners. However, we also see a lot of, as Rocky earlier mentioned, the development is quite rapid, quite fast. So and also especially after the FinTech Week in November. So Rocky, would you like to share some of the new exciting development with respect to VA?
Yeah, I think the FinTech Week really is quite exciting in terms of the VA side of things. We anticipated quite a bit because we have been through different industry associations, government committees, regulators discussion, industry stakeholders meetings, etc. We've all been pushing for kind of the further development, whether legal side or commercial side, for the VA industry. And it's great to see the government policy statement that was issued on the day, and it's quite a clear intention, express intention in particular, to further develop the VA ecosystem in Hong Kong, which is great. I mean, it's not just a virtual asset. I mean, it's in there. You see kind of the references to Metaverse, Web 3.0. You also see kind of the initiative from government mentioning tokenized green bonds, the EHKD, the Hong Kong stable coin concept, and it's encouraging for the government to recognize expressly the potential of the industry with the talent and capital potential. And it's great to see kind of the aligned direction of where the government policy is going. And of course, more in particular, the SFC issued some very kind of encouraging announcement as well. First is the virtual asset ETFs. So that's a synthetic at the start. So that's quite encouraging, and definitely it's in a sense ETFs or ETPs, exchange traded products with virtual asset as underlying. It has been happening in the US, like Canada, North America, and also Europe. So it's great for Hong Kong to pick it up, and I think it will be kind of one of the first and the leading jurisdiction to have virtual asset ETFs in Asia. It then has the consultation over the fast regime under the AMLO. So it's the virtual asset service provider regime governing the non-security centralized VA exchanges. Initially, it was for those exchanges, it's limited to have professional investors only as clients. Now, the consultation will consider expanding it on a certain basis to allow retail access to trade those virtual assets on those exchanges. So those are kind of quite encouraging developments. And I think another observation I see is we always get asked whether there's concern in Hong Kong looking at mainland China's stance towards virtual asset. And of course, we see the autonomy, independence in terms of how the Hong Kong government is pushing forward on the virtual asset side. And of course, it's quite an encouraging message for the Hong Kong VA ecosystem and stakeholders as well. So that's definitely great.
Thank you, Rocky. So the very fascinating development. So obviously, with respect to tax, Brenda, you've mentioned earlier that there's the DIPN 39. However, the DIPN was actually revised back in March 2020. So in terms of more recent development, is there any kind of indication from the IRD that they will kind of get to revise the DIPN again, or is there any kind of intention from the government to even do so?
Yeah, actually, we asked that question when we first talked to them on the draft, and we said, well, when's the next time you're going to revise it? Because things change very quickly, right? And they said probably not until, not sure if everybody knows about the BEPS 2.0, base erosion and profit shifting project initiated by the OECD. So because this DIPN is not just about digital assets, it's also about digital economy. And so I think the IRD wanted to see more developments from a BEPS 2.0 Pillar 1 perspective in relation to digital economy before they update the whole thing. And developments on that side is still going a bit slowly. So I think that question was actually raised again during a recent event. I attended a conference that I attended. I was sitting next to the Deputy Commissioner on a panel, and that he actually laughed and said, well, it takes quite a bit of time to update a DIPN. By the time it gets updated, it's outdated already. But I think he welcomes the idea of providing less formal sort of guidance in the website in the form of FAQs. So that may be something that he will be considering doing. Obviously, they are very busy with other things at the moment, FSIE and other stuff, but hopefully when he gets a bit more time, he may provide more guidance on the website.
And I think as both tax and legal practitioners will definitely welcome some sort of guidance rather than just basing on the revised DIPN, which was already 2 years old, and also based on the traditional tax principles and also tax accounting policies. In terms of the different type of virtual assets, I think it's actually easier for people to understand how cryptocurrency works in comparison to NFTs. So, for example, people often actually get confused with what rights they're actually getting when they purchase the NFT from the creator or actually from the subsequent sellers. So, actually, Rocky, then this question's for you. What rights are actually passed on from the creator to the purchaser, and also what rights are passed on in the subsequent sales?
Yeah, I think that raises a very, very good kind of legal question. I mean, a lot of the NFT transactions out there, I'm quite confident a lot of them don't actually know what they're actually buying from a legal perspective. Now, it could be in different shapes and form. Again, it all depends on how the particular NFT, so to speak, is structured. For example, it could be originated from having a creator, whether it's an artist, whoever, that actually created an art piece or digital printing, whatever, which represents the actual intellectual property. That creator could then grant a license to an NFT issuer. The issuer would then sub-license it to an NFT holder, which then have right to use. It's a subsequent trading, so to speak, or transaction. It may just be a transaction regarding that sub-license. So it all depending on the terms as to whether, because you don't actually hold that IP ultimately. So you actually haven't bought the underlying IP. You just bought a sub-license to use it and pass this NFT on. There could be other representations. So virtual land, for example, again, it all depends on the terms and conditions. It may well be just a right to access certain things, and it's presented in a format that it's a land, for example, and you can do things with it. So it's more like a right to certain things. Now, obviously you don't actually own any piece of land, and there's also a question mark as to what happens if the underlying operator no longer support the underlying blockchain or underlying NFT. So you no longer have that access to the platform. So if the platform does not exist anymore, so what do you have? What do you own? Because you only have the right of. So it all depends on what you have, and some would actually with asset-backed NFT actually represent an ownership of an underlying asset. There could be tokenized securities, for example. So owning the token, it's actually a representation of ownership over the underlying security. So it all comes in different shapes and form, and it depends on what you're actually buying. And from a legal perspective, it will be reflected in the underlying legal documents. And that's how we are helping kind of our different clients structuring different TA-related transactions as well.
Thank you, Rocky. Though you did mention about, for example, an artist creating a piece of art and have a kind of IP registered before the actual NFT side take place. What if the artist forgot to register the IP? What happened then? So based on the smart contracts, I guess the artist will still get the reward. So then, what sort of rights is passed on in that case?
Yeah, so that will go into quite interesting IP law legal arguments. But from an IP perspective, as far as I know, the registration will give you quite good protection. But without that, you could still have rights. So you could still make a claim. So then the legal question would then becomes, okay, who would that person claim against? Would it be the NFT issuer or would it be the NFT holder? And who are actually creating the initial IP or any additional IP on top? So and it becomes quite it's quite an interesting legal kind of situation if we look at that. It depends on who you're representing. Obviously, there will be different legal arguments to go one way or the other.
Thank you, Rocky. So again, also with respect to NFTs, so I'll briefly mention due to the smart contract these days, so the creators can actually earn reward from subsequent secondary sales of their NFTs. The question is whether the reward can be regarded as royalty. Based on Rocky's answer, it feels like it might be regarded as royalty because it involves IP and rights. So Glenda, what are your thoughts on this?
Yeah, I think similarly, it really depends on what you're paying for. So in the tax world, a royalty usually refers to payment for the right to use intellectual property rights. So if there is no such elements, because there can be situations where you're just buying something without the use of the underlying intellectual property rights. If there's no such elements, that's not a royalty for tax purposes. So it's really necessary to understand the exact nature of payment. And the reason why this is important is because in most jurisdictions, a cross-border royalty may attract withholding tax. If it is for the commercial exploitation of intellectual property rights. So if it is indeed the case, the buyer may have the withholding obligation if the payment is made to an overseas seller. And usually this would only be relevant if the buyer is a business, because if you are just an individual, it's unlikely for you to be commercially exploiting those rights unless you are carrying on a business as an individual. But if withholding is relevant, I think the practical issue here is a lot of times the buyer doesn't even know where the seller is, right? Everything happens on the blockchain. I don't even know the identity of the seller. So it's hard for me to know whether I actually have the withholding obligation. If the seller is just a Hong Kong person, I'm a Hong Kong person, there's no withholding, right? But if you're sitting outside of Hong Kong, then there could be withholding. So I think this illustrates the situation where the law can apply, the existing law can apply, but it's just that practically the administration can be a difficulty.
Thank you. Actually, the next question is also for you, Granda. So
Yeah.
may I also ask you, and I think this question is a question we all have in mind. So when will the IRD actually deem an event to be a taxable event? So with respect to the cryptocurrency and NFT transactions. So for example, how does the IRD find out? And as you mentioned earlier, how can the IRD actually find out a person's cryptocurrency or NFT trading? And once they find it out, how does the IRD actually tax such transactions?
Right. I think the first question we should be asking is, who is this person? Is he an individual or is it a company? Because unlike many other jurisdictions, individuals in Hong Kong, as we all know, we are only taxed unlimited income. So we pay salaries tax if we earn employment income or income from holding up an office, for example, director's fees. We pay property tax if we receive rental income on real estate, and an individual can also pay profits tax if the individual carries on a business in Hong Kong and derives onshore source profits from that business. So generally, if I'm just, an individual not carrying on a business, and somehow I don't want to use the word trade, but I buy and sell cryptocurrency and I earn some money, that's not taxable. Just similar to when I buy and sell shares, the RJ is not going to tax me. So now let's say, so whether an individual carries on a business in Hong Kong is a question of fact based on all the circumstances. And there's actually a number of case law there, both in Hong Kong and overseas, like the UK, on determining how or whether an individual carries on a business in Hong Kong. And interestingly, a lot of these cases are because the individual wanted to claim losses from the securities trading business. And in most of these cases, they lost. Because the court, basically, they would look at whether there is a habitual and systematic course of dealing. And in most situations, these individuals don't have this. And also, we have not yet seen the IRD actively pursuing individuals in terms of dealing in investments, whether securities or cryptocurrency, as yet. But on the other hand, if the person you're referring to is a legal entity, is more likely to be regarded as carrying on a business, and therefore the entity will, it is supposed to report all the transactions, whether it's dealing in crypto, whether it's dealing with any other things, in its financial statements. So basically, how the IRD finds out is to look at the financial statements of the entity and to spot any, cryptocurrency dealing. Yeah. In terms of how then this person is going to be taxed. So in calculating the taxable profits in Hong Kong, obviously the starting point is generally the accounting profit. So the first question is how such cryptocurrency trading or NFT trading would be accounted for in the financial statements. And cryptocurrency is not money, right? So depending on the exact nature of the specific crypto, it can be accounted for as inventory, as financial instrument, as intangible assets. And so when the person initially purchased the crypto, let's say with fiat currency, with cash, it's just like using money to buy assets. So there is no taxing point there. Now, let's say the person holds on to the cryptocurrency and without any further transactions during the year. So the value of the cryptocurrency can go up or down, obviously, fluctuates quite a bit, especially lately. And for accounting purposes, there may be a need to revalue this cryptocurrency at the end of the year in the balance sheet. Now, as a result, there will be a revaluation gain or loss sitting in the accounts. And the question is whether this revaluation gain or loss is taxable. In Hong Kong, we have case law saying that unrealized gains should not be taxable until they are realized. And equally, unrealized losses should not be deductible until the asset is realized, unless the loss represents a diminution in value and it is likely to be permanent. But actually, there is now an election to elect for a fair value treatment, fair value basis of accounting if you account for the financial instrument under HKFRS 9. So there is an election there, but generally it is on a realization basis if you don't go for that election. Now, suppose, unrealized gains or loss, generally not taxable or deductible. Now, let's say the next year, the person then converts the crypto into another cryptocurrency. So not yet fiat, right? Now, whether that transaction gives rise to a tax would depend on whether there is a gain arising from that transaction, because exchanging crypto with another crypto is actually like a barter trade, right? So there could potentially be a gain booked in the accounts, and if so, even though you have not yet converted the crypto into fiat, there can still be a gain that is taxable. Yeah, so that's how the overall thinking works.
Thank you. So in that case, so you, obviously then if you kind of convert the cryptocurrency back to fiat, there will be another kind of taxing point there.
That's right.
Yep. So I guess the thing is that if, say, for example, obviously there might be people doing this out there. So if they don't actually report it in the financial account, is there any way for kind of the IRD or the government to check? Because I mean, blockchain is built on kind of ledgers, and with smart contracts, you can actually find each individual. You can trace all the transactions from the original one all the way to the latest one. So is there any way kind of for the government to, or the IRD to keep track of that?
I assume there is a way because it's a blockchain, but whether they do it or not, I don't think the IRD is that advanced yet, to be honest. So at the moment they don't. But obviously that's not just a matter for the Hong Kong IRD. Obviously, tax authorities around the world are facing that issue as well because of the lack of visibility to these transactions. And therefore, the OECD has come up with something. So the OECD recently published a guidance on the crypto asset reporting framework, what we call CARF, and amendments to Common Reporting Standards, CRS, in October this year. And basically, it sets out a global tax transparency compliance framework with model rules for automatic exchange of information between jurisdictions in relation to financial accounts and crypto assets. So the framework essentially requires intermediaries and service providers to report certain tax information in relation to transactions in cryptocurrency. And so going forward, if these model rules get implemented into local laws of jurisdictions, basically tax authorities will be readily able to get such information.
Thank you. So I think now it's actually a good time to change the topic, and we'll talk about Metaverse. So in Metaverse, a decentralized platform, so users are able to kind of sell and purchase virtual lands, NFTs, and virtual goods using cryptocurrencies. So Rocky, how can the government regulate the sales and purchase of these virtual assets? In fact, should the government be regulating these activities at all?
Yeah, I think that's a quite very interesting question, because it resembles when the internet first started, and there was questions asked whether there should be laws specific to the internet, or the internet could exist in a vacuum and not governed by any law. But of course, as we see, different jurisdictions will still govern the activities over internet, and they still use traditional legal framework, etc. So I don't expect anything different to the metaverse. And just in terms of how it's regulated right now and how it could be regulated, I think it's always a step-by-step process. And in a way, it's similar to how virtual asset has been regulated. So at the kind of beginning of everything, when it first caught attention, the VA, the way the regulators and the government reacted is to regulate it using existing legal and regulatory framework, basically taking a technology neutral stance and regulate with existing law. Metaverse, same thing. You apply the same securities law, consumer law, AML requirements, etc. Now, the problem is, as you can see from the VA development, because it could be a lot of different things. And there are a lot of uncertainties, and there's certainly regulatory gaps in different areas. And that's why you've seen in Hong Kong, for example, you've seen the regulators coming out issuing regulatory guidance in terms of explaining how they would apply existing laws in the VA context. There are also new laws being introduced, specifically cover any gaps. There are discussion papers, consultations coming out that will govern more VA-related activities. For Metaverse, I would think they will adopt a similar approach in terms of how the law and regulations will, in a way, catch up if need be, from a legal regulatory perspective. But just for the Metaverse, obviously, it's a lot more than just VA. There will be a lot more products, services, and a lot more you can do within the Metaverse. But in that sense, then there will be activities that may just be normal activities over the internet. It could be similar. It could be more specific, quite different. But again, a lot of the existing laws and legal framework may well be enough from a conceptual perspective. We'll be able to cover those activities already.
Thank you. And then my follow-up question will be actually regarding to, obviously, Metaverse. It's actually a decentralized platform. So the whole concept of decentralization is there's minimal interventions with one central body. So then the question is, if the government try to introduce regulations or trying to regulate the whole ecosystem, then would that kind of defeat the original purpose of having everything decentralized?
Yeah, again, it's in a way, the way I see it is we do need to recognize the ecosystem. It does not exist completely independent to the rest of the world. And from my perspective, I think the key is to bring alignment between whether it's Metaverse or the VA ecosystem to the kind of traditional, whether it's financial industries or other industries. The regulations, I don't see it's going to be contradictory for the benefits decentralization may bring about. But on the other hand, we know that these type of activities, we ought to have certain regulations just for there to protect the public. As you may, all may have seen the recent incidents in the market. And of course, a lot of times is the question is whether, okay, that there should have been regulations. So the market or investors are better protected, or if there's so strict regulations in the first place, there's no development of that ecosystem at the beginning. So ultimately, then becomes a question of where the balance should be, and that's exactly what the government and regulators in different jurisdictions are tackling right now. And it's quite interesting to see different jurisdictions. They're actually taking different positions, and there is no right or wrong answer, depending on your the perspective you're looking at.
Thank you. So Now, Gwenda, so obviously you might be aware of my next question is then how would the IRD tax the gains and loss made in the metaverse? So from your previous explanations, it sounds like the IRD has been applying all the traditional principles. So would that be kind of the similar cases for taxing the gains and loss in the metaverse?
Yeah, actually, there's no difference between transactions happening in the metaverse or happening in the real world. After all, metaverse is still operated by real people, real entities. So basically, let's say I open a store in the metaverse selling clothes, and someone in her avatar came in to buy clothes, pay me crypto or pay me, I think mostly crypto, then I'm supposed to report that transaction, all the gains from that transaction and get taxed on it.
Thank you. So we've actually covered quite a lot this evening, and I think that was actually a good time to kind of follow up with one of my earlier questions regarding to DIPN and also whether the government should be introducing legislation. So obviously you mentioned the IRD has no intention to revise the DIPN until the BEPS Pillar 1. But in terms of that, I guess then the thing is that it doesn't stop the government from introducing a new tax regime on the taxation of virtual assets. As you can see, I guess from the recent development of the foreign source income exemption regime. So obviously the EU is kind of like pressurizing Hong Kong to make the changes, and we did it in a kind of record time. And so do you think the government will do something with regards to like taxation on virtual assets?
Yeah, that's a good point that you brought up. So in recent years, we're actually seeing quite a lot of intervention by international organizations such as the EU, the OECD, in terms of tax regimes of other jurisdictions. And as you mentioned, our foreign source income exemption regime has to be revised as well because of pressure by the EU. Now, I think what they've been trying to do is really to promote fair tax competition, and basically they are setting these international standards and asking jurisdictions to follow. Actually, it's not just recently, because say in Hong Kong, actually the introduction of the FSI regime is not the first time where our tax law gets affected because of OECD or EU. You may remember that around 2009, we were actually, the OECD actually threatened to put us on their grey list because of the lack of treaty network in Hong Kong, and therefore the lack of transparency. And also in 2018, we actually had a big revamp of our tax law as well, because we need to implement the base erosion and profit shifting measures, BEPS measures, including the introduction of formal transfer pricing rules. So basically, I think we are just seeing more and more coming. As you know, BEPS 2.0 is coming as well. So I think, unfortunately, the OECD and EU will keep reviewing, the tax law of different jurisdictions, and we basically just have to see how they come. As I mentioned, the CARB and CRS framework is coming as well, so that's very likely to be adopted in Hong Kong as well.
Thank you. And then in that case, because as we can see, major kind of changes to our tax law is because of like outside interventions, pressure. So, and as you may be aware, there are, I guess, the tax development with respect to virtual assets in other jurisdictions is actually much faster than Hong Kong. So say, for example, Australia and the EU. So in that case, do you see that they will kind of, again, being pushed, so Hong Kong's being pushed to make certain changes?
I don't really see the need for change. I mean, this is also a question that was discussed when I was with the Deputy Commissioner in that panel. He didn't think there's a need to put forth any changes because he thinks that the existing framework is sufficient to cover. And I kind of agreed with him as well. And if you look at other jurisdictions, actually not many of them have put in place new tax law for virtual assets or cryptocurrency. In fact, they are also applying existing law. It's just that they are more advanced in trying to provide guidance as to how they will apply the existing law on these type of transactions. So my thinking is that if not pressured by the EU or OECD, the IRD may not see a need to change the law.
And then I guess now we can talk about some of the incentives. So obviously Hong Kong has been trying to attract more private equity fund to set up here. So do you think the virtual assets should be included as a qualifying transactions for the purpose of the private equity fund exemption?
Yes, that's something that we've been trying to push for years with the government. And obviously, when you tell the IRD about this, they're going to say, well, this is a policy issue. We, as the IRD, is just an administrator of the law. So that's not something we have a say. You should talk to the FSTB. So in more recent years, we've actually pursued directly with the FSTB. And I think we are starting to get more buy-in. And obviously, it also depends on the appetite of the government as a whole on cryptocurrency, virtual assets. And based on recent remarks by the government, and obviously, Rocky shared a lot of the positive developments lately, it seems that the government is quite committed to promote Hong Kong as a virtual asset hub. So I think I'm quite hopeful that the government will seriously consider including virtual assets in the unified fund exemption regime.
Thank you. And I think we've still got time for one more question. And this question will be for Rocky. So actually, and it's actually a more recent kind of news. So if you follow the virtual assets kind of sector, you will know these news. So with the recent collapse of the FTX and the latest actually bankruptcy application filed by BlockFi, and in addition, there's actually growing fear that Genesis might actually go bankrupt as well. And Rocky, do you think there's any kind of intention for the Hong Kong government to further regulate the centralized crypto exchanges, or will the government simply do nothing and people will just simply go to a decentralized finance platform?
Yeah, so I think that's the recent development. Yeah, because it's quite an interesting time. It's kind of shortly after the FinTech week, in a sense. And we also have a lot of inquiries to think, okay, will things change a lot, or will it really affect timeline? But I actually think it's kind of in line with what we are trying to achieve as an ecosystem, and also the government and regulators as well. It's having regulations. The importance is that it is clear and it's commercially workable within it, and that's what's important. And I think for the government and regulators, there is the incentive to move towards that. And obviously, we can't be too pragmatic at times, and we do need to apply certain standards in terms of the regulations over the operations. And the recent incidents, FTX and others, it is actually quite shows very good examples on why we do need certain benchmark or standards from a regulatory perspective, in order to protect the wider public and investors, and also for the healthy development and growth of the whole ecosystem as well. So I think it's actually aligned as to what we are all trying to achieve here.
Thank you, Rocky. So I would like to open up to the floor for Q&A. So anyone got any questions regarding? Yes, the gentleman over there. So.
Hi, my name is Kevin, and we are running our Web3 company in Greater China, in Southeast Asia, and in Europe. And I do have a few questions. First of all, I got two questions for Gwenda. The first one is that you mentioned about valuation on financial statements. I would like to know whether there is like specific ways to evaluate. Let's say we're talking about the last day of the closing day of the balance sheet, and so you are taking that specific day and specific time on such valuation of such, let's say, cryptocurrency or NFT. So how do you do this valuation? This is the first question. Second of all, when we're talking about like and let's say for NFTs or cryptocurrencies, they're kept, let's say, in a Metaverse wallet. But how do you do that? What we call the ownership proof, because it's, you cannot prove the identity of who is owning this wallet. Let's say someone like Elon Musk, he is having like billions of dollars of like worth of digital assets in his wallet, but it's very difficult for you to like prove he is actually owning the wallet. Not to mention that the company is actually owning the wallet instead of a real person. So this is the question. This is the second question I would like to ask. And the last question I would like to direct to Rocky. And when we talk about virtual assets, I think right now we are focusing more on cryptocurrencies and NFTs. So what about if we were talking about some non-crypto based digital assets? Let's say for in mainland China, we have a blockchain network called BSN, the Blockchain Service Network, and they are talking about non-Ethereum, non-crypto based Ethereum chain. So we have this kind of digital assets on this blockchains. Whether or not do you think this should be categorized as virtual assets that should be regulated by the Hong Kong government, let's say? Thank you very much.
Thanks, Gavin, for your questions. Unfortunately, I should have brought my valuation expert and my accounting expert with me, but based on my limited knowledge, I think from a valuation perspective, generally you look at the last day, the balance sheet date, right? So you make reference to the fair value of those assets as of that date. That's my general understanding. As to the proof of ownership, again, I think that's actually a tricky question that our accounting colleagues were trying to figure out when they first take on crypto clients. How do you actually prove that the wallet belongs to you? I think there were some discussions as to whether, who holds the key, right, to the passwords to the wallet. So can you prove that it's the company's own staff or somebody else? I think that those may be factors that will be taken into account. Not sure if Rocky, you may have some thoughts about that as well in terms of ownership of a wallet.
Yeah, I mean, that's an interesting thought, because ownership, I guess, in terms of the proof for blockchain, it's basically, we've looked at it earlier, and it's basically who holds the key. So you have that possession, but you do have a possession of it, but does it prove ownership? It's from a legal perspective, it gives you that kind of indication. But ownership could then be contracted out, as you know. So someone may be holding the key on trust for someone else. So then it brings back into the ordinary legal concept as to who is holding what, and of course that's kind of the legal analysis. In terms of the proof, then it goes down to, okay, who actually holds the key, and whether there are any other legal documents that kind of support the legal relationship between the different parties.
And there was another question.
There's the third question.
Yeah, the third question. Yeah, it's quite interesting, because the definition of virtual asset, the term has evolved from crypto assets, digital assets, virtual assets. There are a lot of different terminologies, and there are a lot of subgroups, stable coins and all different kinds. The regulators are trying to find a definition. But all in all, it's aimed to be relatively broad and flexible and try to capture a lot of things. So whether it is crypto conceptually, or whether it's on whatever type of blockchain or different technology, it could still be caught. So it depends on the actual definition under the law, but the aim is to cover a wide range of instruments, or asset, or however you call the underlying. And I think the regulators, where they're coming from, is to regulate the risk involved. So and rather than looking at the underlying technology. So if you use different underlying technology but represent similar nature of what you're actually doing, representing similar risks, then I would expect the regulators will try to regulate those different technologies in the same way.
Thank you. So is there any other questions?
Thank you. I want to ask questions about the law of the virtual assets. A source laws, the cryptocurrency token and NFT is a good tools to be anti-money laundering and the money laundering tools. Yeah. Rocky, what do you think? How about the compliance law or the anti-money laundering law will be changed because the development of such kind of the virtual assets? If the anti-money laundering law will be changed, it will be affect the development of these such kind of assets in the future. As you know, nowadays the AML, CTL is very strict in the kind of the financial institutions industry. So, what's your thoughts about the AML and the CTL development on such kind of the assets? Thank you.
Yeah, thank you. I think it's you spot on. AML, CFT. It's kind of the top priority from a CA regulatory perspective. That's top of the agenda for globally for regulators. And for FATF, the AML global governing body, basically, one of the key recommendations that all member jurisdictions comply is to regulate virtual asset service provider. And all jurisdictions will need to do it. That's why you see a lot of jurisdictions that came out new laws to regulate VA activities, and a lot of them are actually covering the AML side of things as a start. So Hong Kong, you see similar items. So we mentioned before the fast regime under the AMLO, which is AML law in Hong Kong, and that covers the centralized non-security VA exchange operation at the start. The law is broad enough to cover a lot of different activities, but as a start, it's the centralized exchange being regulated. And it's in a way the AML side of things, that's how the law are catching up, and all jurisdictions are pushing forward to it and applying the AML law to it. Now, it's quite difficult in terms of doing the travel AML law checks, etc. There's the travel rule concept, basically to try to ensure how you can trace the source of the virtual asset that you're dealing with. There are talks about using different technologies to support that. So that's all in development. So and it all goes in line with the regulators trying to regulate different operations and service providers, industry stakeholders, players. And with that, other than the usual, okay, you need a license, you need to check the suitability, disclosure, etc. AML will be the key one. So whenever you onboard a client for whatever services in VA you're doing, you need to do your AML, KYC, customer due diligence requirements. So I think the world will develop that way in terms of covering the AML side of things.
Thank you, Rocky. So I think there's one more question.
Thank you, panel, for your presentation. One question and one addition. About the federations, to the gentleman, I just know that in general, a lot of exchange platforms use different federations. So the most challenging part is which federation to use when you do your accounting, basically. So that was just a clarification or addition to the question. My basic question is actually, would the panel think there's a difference between virtual land and an NFT? Because some people would claim that virtual land, an interest in land, is actually equal to an NFT. You guys mentioned it separately as a virtual asset, but would you not think it's the same?
Perhaps I'll pass on to Rocky to define from a legal perspective first, and I'll come back to the tax perspective.
Yeah. So it's you raised a very good point. What is NFT and what is virtual land? I mean, the lazy answer is it depends. But a lot of time is NFT. You may call it an NFT, but from a legal perspective, we still need to analyze it, whether it is actually non-fungible, whether you're fractionalizing things, whether one can actually represent the other. So we do need to test it from a legal perspective. So for a virtual land, it could be an NFT or it could be something else. But it depends on what you are on the actual underlying legal structure on how the virtual land or the so to speak NFT is issued.
Thank you. I think similar from a tax perspective. From a tax perspective, it doesn't really matter what it is called, because again, we need to look at the underlying nature of it. So I think recently a client called me up and asked, well, I bought a piece of virtual land. Can I claim any tax deductions or depreciation or any allowance on it? Well, I said, well, what exactly is it? It's a right for you to build something on it, right? You can further develop the land. You build some further programs on it, but the land itself does not qualify for any deduction under the Inland Revenue Ordinance, right? Is not a even if it's an actual piece of land, there's no depreciation allowance, right? Because it needs to be a building. So it's not a software, right? So if it doesn't qualify for anything under the Inland Revenue Ordinance, then you get no deduction. And similarly for NFTs, what exactly is it? It is an intangible asset. So do you qualify for any deduction? Well, I guess unless you treat it as a trading asset, then probably yes. But otherwise, if it's a capital asset, then there's nothing in the RO that says you can claim any deduction on it. So I guess really depends on the underlying nature. That's my view.
Thank you, Gwenda. So I think we're running out of time, so I'll just do a quick summary of tonight's event based on Gwenda and Rocky's comment. So obviously we're seeing quite a bit of actually the development with respect to the legal side of things are actually quite fast. It's following the actual trend. However, with respect to the development of tax laws on the virtual assets in Hong Kong, is actually relatively slow in comparison to other jurisdictions around the world and in comparison to the legal development. I guess, however, as we can see from both the legal introduction of the legislation and also by applying the traditional kind of accounting and tax principle, this is all kind of pursuant to the rule of law, so which underpins the way how our society operates fundamentally. And also with these kind of fundamental tax policies that underpins every tax systems around the world, then actually it's contrary to what people believe is every transaction that occurred, and in fact, every actions that you take will have some sort of tax and legal implications. Meanwhile, so blockchain technology has been kind of continued to develop, and as a result, as we can see, the virtual assets and metaverse continues to evolve. But I guess the lesson from tonight will be, regardless, it will always be subject to some sort of tax and legal governance. That being said, for the time being, in terms of from a tax point of view, we'll just have to apply the traditional kind of tax principles when dealing with taxation of virtual assets. And so I would like to take this opportunity to then thank our speakers, Gwenda and also Rocky, for sharing their insights, knowledge, and expertise in virtual assets from the both tax and legal perspective. And I would also like to thank University of Law for co-hosting the event, and further a big thank you to PwC for sponsoring the venue. Last but not least, thank you all for attending. So there's one other thing, actually quite important. So if any of you would like to attend future kind of IFA and Yin event, then please do let me know. And also IFA Hong Kong membership is also available to all. So if you'd like to learn more about it, please let me know as well. So for those who'd like to network afterwards, please come grab a drink and have a chat with us at the Mo Bar. So thank you and have a nice evening.